Welcome to Simply Legal, Medfield's local TV program which addresses a variety of legal issues. I'm your host, Geraldine Warren, a Medfield resident and practicing attorney here in Medfield. Today I have with me Jessica Bobb, who concentrates her practice in Chapter 7 and 13 bankruptcy law and also in family law. Next month, I will have David Madoff from the Madoff & Curry firm, who will be discussing Chapter 11, which is business bankruptcy, and Chapter 9, which is municipality law. So welcome, Jessica.
Thank you for having me.
I thought maybe we could begin with just giving the community an overview of what Chapter 7 is, and then an overview of Chapter 13, and then we can maybe get into the specifics of each.
Sure. A Chapter 7 bankruptcy allows a person to have a total discharge of all their debts, whereas a Chapter 13 bankruptcy, you go on a 5-year or 3-year payment plan where you pay a certain percentage of your income to the creditors through the trustee's office, and then at the end of that period, the remainder of the debt will be discharged.
Okay. In Chapter 7, is there some way that you have to, that you determine whether someone can go ahead and file Chapter 7?
Yes, there's a qualifying test. It's called the means test. And with a Chapter 7, there's certain income guidelines depending on the size of your family. They're all on the U.S. bankruptcy website, so you can kind of take a look and see if you'd fall under the guidelines. So it takes the income of the entire household over a 6-month period, and if you fall within those guidelines, you're able to qualify to file for the Chapter 7. If you are above the guidelines, or if you have a little bit more disposable income, then you have to go ahead and file the Chapter 13.
So when they're looking at income, so if there's a spouse situation, a husband and wife, both of their incomes are put into effect, like is considered?
Yes, both of their incomes, and if they even have an adult child living with them contributing to the home, their income would be as well. It's the entire household that they live with. So.
What if their children are like adults or over 18, yet they're in college, so they would not count? They're obviously, they wouldn't have income. So just something they made in the summer wouldn't count, would it?
No, they would just count for the household size.
Okay. Also, now with the husband and wife, even if, let's say, one person was signing on certain things that caused them to go into bankruptcy, is the husband still, his income is still put into effect, is still considered in determining whether you can file Chapter 7?
Yep, the income, even if they're not filing jointly, if they're filing individually, the husband's not filing with the wife or vice versa, it's the entire household income that goes into effect for the means test.
Okay. Is there a means test for Chapter 13 as well?
There is. It's the exact same thing as a Chapter 7, because what you do is you want to be involved in a Chapter 7 because it's a full discharge of the debts, unless there's a certain factors we have to look into whether or not you might want to put into a 13. So you're going to do the means test regardless for all of them. With the means test for the 13, it's pretty much looking to kind of see what your disposable income is, and that's the money they're going to be paying into the plan every month.
So Chapter 7, you would say, would be preferable because you would get the discharge, whereas in 13, you would still have to pay your creditors, but you are given a period of time over which to pay them, and does the trustee make that determination of how much you pay? Or
you develop what's called a Chapter 13 plan, where you take the disposable income and you kind of look at all the debts that they have, and it gets stacked by priority debts, secured debts, unsecured debts. And then it'll pay out of that. So if you have student loans, that's a priority debt. Any child support payments or alimony payments, those get paid 100% out of the thing, and then whatever you have left over, it could be 1 cent on the dollar to your unsecured creditors. Whatever you can pay them is what they get paid from that small portion of your disposable income. It gets paid to the trustee directly, and the trustee will pay out the creditors from the plan.
So if you do file, if you're not able to file Chapter 7 and get the discharge, and you do file Chapter 13, you would actually have to have income coming in order to make this payment, isn't that right?
Yes, the trustee and the courts both have to approve the plan before it goes into effect. So that's most of the time you will have to have the income to be able to pay. If you have this, the income over the guidelines for the Chapter 7, you generally will be able to make the payments into the 13.
Okay. So under Chapter 7, I've heard that called a liquidation chapter or a discharge chapter, but under Chapter 7, is there any property that would be exempt when you're going to file?
Yes, with a Chapter 7, most property is exempt. It's a good idea to make sure you list everything you own, including clothing, any jewelry, anything like that. Pretty much everything you have is exempt there's exemptions listed for everything: houses, cars, any other property, any clothing, any expensive jewelry, antiques, collectibles, anything like that. There's a 401ks, pensions, retirement plans, life insurance plans. So there's exemptions for all of those, but you have to make sure that you list them or you let your attorney know about them, because if they're not listed and if they're not exempted and a creditor shows up at the 341 creditors meeting and says, hey, this person has this asset, it's not listed there, it's not exempted, the trustee can take that asset, seize it, sell it, and pay off the creditors with that asset.
So that's a really important point to make. So if people think, oh, I'm not going to list it, then they're not doing themselves any favors, because it could be exempt, and if they don't list it, it's not exempt, and then someone can come in and make them sell something that could have been very valuable.
Yeah, it's better to list everything over extent. Make sure the littlest things, make sure you make sure your attorney knows that you have them, and they can most likely exempt them.
You mentioned cars. What if you were leasing a car? Are you allowed to continue that lease, or do you have to?
Yep, there are a few different options you can take. You can, if you want to continue leasing it, you're able to maintain the lease just regularly through the bank. And you can just what's called a statement of intent, and then through that statement of intent, you can either reaffirm the debt, you can retain and pay pursuant to contract, which is typically what we do for something with a lease. Car leases, apartment leases, anything like that, you can just keep, even the phone lease, the phone contract is technically a lease. So you would do that with that as well.
And now Homestead, because I do estate planning, a lot of times I do homesteads on homes. So this is a case where Homestead would be a good idea?
Yes, a homestead, if you have equity in your home and you want to keep your home, you want to make sure Homestead is filed. You would most likely use the Massachusetts exemptions because they allow for a lot more for the Homestead. There's an automatic $125,000 protection without filing a Homestead, but if you file the Homestead, you have up to $500,000 protection. So if you have equity in your house, you want to make sure that the Homestead is filed and with the registry prior to you filing the bankruptcy. It can be just a couple days before, it can be the day before. It has to be on record with the registry before you file a bankruptcy to be able to save the equity in that home.
So that's worth a $36 filing fee. I had the registrar of Norfolk County Registry of Deeds here last month, and we were talking about the homestead. So it's funny that it would come up again this month. But I mentioned to the community that if they wanted to do a homestead on their home, that I don't charge for homesteads, but there is a $36 filing fee. So it really makes good sense to have a homestead on your home, especially in Massachusetts because of the $500,000. And then, in fact, seniors and those that are disabled get a little bit more protection because they can stack their homestead. So that's a good point to make. Now, within the federal and Massachusetts, are there differences in what property is exempted? Or?
Not really in the properties, it's just the amounts you can take with the exemptions. Depending, if you have a home, you typically want to do the Massachusetts exemptions because of the homestead provision. If you don't have a home, the federal has a little bit more for the wild card exemptions, which you can use if you have something that is over the value of what the exemption allows.
Can you explain the wild card exemption?
Yeah, I don't know off the top of my head the exact figures of what they allow, but if you have a car and it's worth a certain amount of money and it's over the allowed exemption, you can take the remainder of that equity in that car and exempt it under the wild card exemption.
So do you? I think is the amount between $1,000 and $5,000? Is that the wild card?
It sounds right. Yeah.
I think that's what it might be as far as the wild card exemption goes. Now, what's the process like? Is it a short process? Is it a long process? Let's talk about Chapter 7, like from the time of filing. Can you bring us through that?
For Chapter 7, the process is actually pretty quick. It just depends on how quickly you get us the paperwork. For Chapter 7. We require, a copy of all your 3 credit reports. You need bank statements for the past 6 months. You're going to need pay stubs for the last 6 months, which will enable you to do the means test. You need your most recent tax returns, preferably for the past 2 years if you can get them to us, and every single bill you have, because if we want to make sure every single credit you have is listed on there, medical bills, everything like that. Most medical bills aren't listed on credit reports, so if we don't have them, we don't know they're there. And again, just like with the property, if it's not listed as a creditor, if it's not listed on there, the creditor's not notified, it's not going to be discharged. So you want to make sure everything you have is on there. If you have collections, you want to make sure we have the original creditor, the collection agency, and everything. It's better to have more than it is to have less.
Okay, so once you get this information from your client, then do you do the means test then? Is that your next step?
We would do the means test probably initially just to make sure
that
to see what chapter they fall into.
Okay.
And then, so once the bankruptcy for Chapter 7 is filed, we get immediately upon filing an automatic stay. So if you have creditors coming after you, or
Can we just explain, because some people might
Yeah.
not know what stay,
Yeah.
what we mean by stay.
So an automatic stay is like for instance, you have creditors or anything coming after you. What the automatic stay does is it prevents creditors from communicating with you or going after you or trying to, I guess, negotiate down like a settlement of the debt or anything with you without taking permission from the court to do so.
So it kind of like puts them at bay.
Yeah, so the collection call should stop. Any court hearings you have for any collections that they have that are scheduled for a future date, any foreclosures that are scheduled, those will be stayed until the termination of the bankruptcy case.
Let's say prior to filing for bankruptcy, you had come up with some kind of settlement agreement with one of your creditors. However, you found that you can no longer, do the 100 a week or whatever you had agreed to. And then the judgment is filed. Will that be part of the bankruptcy? Will that judgment go away?
It will. Yep. So
Okay.
you go into the bankruptcy. A judgment on, I believe it is, if you have an eviction for property and there's a judgment on that eviction, the bankruptcy will not stay the eviction. The eviction will still go through.
Okay.
So.
But if, let's say, you had a creditor and you owed them like $40,000 on a debt for an accountant that had done work for you or whatever it was, and you got an agreement to go ahead and you signed the agreement that you would pay him, $200 a month or whatever, you no longer were able to do that $200 a month. One of the parts of the agreement or settlement was that then a judgment would be entered. So that judgment that's entered would be discharged in Chapter 7?
Yeah, everything. If you want to probably try to file before the judgment even gets entered, but you do list all your judgments and everything in the bankruptcy itself, and then you get notified of the bankruptcy and it will be discharged as well.
Okay, so now we're at the point where they came to you, they got you the information, you did the means test, and Chapter 7 will work, so now you filed. What happens next? And can I ask you the filing fees? Because it's important for the community to understand that there are fees involved with just filing.
Yep, for the Chapter 7, it's a $306 filing fee, and with the Chapter 13, I believe it's a $286 filing fee. Once again, all this is listed on the bankruptcy court website, so if you need to go on there and take a look at it. I might be a little off on the Chapter 13. I can't remember off the top of my head. I do a vast majority more of Chapter 7, so I just know that very much.
Okay, so now we're at the filing. Do you want to take us what happens next?
Sure. After the filing, about 30 days, immediately upon filing, we'll receive a notice, essentially, from the bankruptcy court with a notice of creditors meeting, which is a 341 meeting. It's scheduled probably about 30 days out from when it was filed. They do about once a month, so you'll have to meet with the trustee. It's a formal hearing. It's with you, the trustee. There's no judge, and it's in a big open room, so it's open to the public. Anyone can go, and creditors have a chance to object to anything at this point. So the trustee will sit down with you. If it's a Chapter 13, they'll go over the plan, approve of the plans, make sure you can afford the plan that you have set out. With the Chapter 7, they'll just kind of go through, make sure you're not having any assets that aren't hidden, that you're not disclosing or anything like that. And then you have the meeting. You wait. You have to do this. With every bankruptcy, you have to do 2 debtor education courses. One before you file.
Oh, yeah, that's right.
And then one after you do the meeting. And so you want to have about 45 days to 60 days to complete that second course after the meeting. You get that in.
Can I just stop you only because I forgot about those meetings. So the first meeting that someone has to do is prior to them filing?
The debtor education course. It's not a meeting. You can do the debtor education courses online, over the phone. There's different websites. It's different costs for different websites. But
about how much are they?
It ranges from about $14 for some websites up to about $30 for other ones, depending on who you use and who you go through. I think the $14 one that I know of, they only offer the first initial course. A lot of people like to use the same company for the whole thing, so it depends. It's preference, really. But yeah, you have to complete it before it's filed.
So now you've filed and you have the meeting, and then do you take the course after the meeting?
You do. You take the second course after the meeting. You have to wait till after the meeting to take the course. You file that with the court, and then depending on how long, if the case is stayed or not, what's going on with the case, maybe about 60 to 90 days later, you'll receive a discharge in the mail for the Chapter 7. For the 13, it's more of a longer process because it's a plan. So if it's a 3-year plan or a 5-year plan, you're paying the trustee for that 5 years. So it's a much longer process because you're paying into that plan.
Do you do the same courses for Chapter 13?
You do.
Okay. So what would you say the process from start to finish is generally for Chapter 7?
For Chapter 7, it's probably about maybe 4 or 5 months total. It depends, again, on how
Sure.
quickly you get us the paperwork.
Just
That's
generally.
pretty much the longest period of time is waiting on the paperwork for the stuff.
And then you were saying with Chapter 13, which is why people don't always like Chapter 13, is because it's just a longer process.
It is.
It's hanging over you for a longer period of time. It's between, you said, 3 and 5 years?
Mm-hmm.
Okay. And, you know, I think that's kind of a good point that they made these courses that people have to take, because kind of makes them aware of maybe what they should do next time not to end up in bankruptcy.
Yeah, the second one is called a financial management course, so it's trying to help you manage your finances a little bit better. And the first one, I think, is like a debtor education course, so it kind of educates them on the different...
On the processes?
Mm-hmm.
Okay. So I guess to kind of summarize, like on Chapter 7 and 13, can you just, for the community, just kind of give a generalization of Chapter 7 and then of Chapter 13 and the major differences?
Sure. Well, the major difference is that one is a complete discharge, and the other one is more of a payment plan. You will get a discharge at the end of the payment plan, but you do have to pay into it for that 5-year period, where you, depending on how much you can pay, you might pay it all off before, you know, it's just a little bit of a variation. Chapter 7 is obviously much more preferable because you do get the full discharge. However, you have to be cognizant of some of the facts. So if you own a home and you're underwater on that home, you're behind on your mortgage payments, but you still want to keep the home, you can't do that with a Chapter 7 because you can't do the back payments. You either have to let it foreclose, short sale it, or you know, kind of do something like that. If you want to keep the home, a 13 is how you keep that, because you'll have to pay the back rent will go into your payment plan, and you still have to continue paying the regular mortgage in addition to your payment plan just as regular. So that's something you need to think about as well, as to what chapter you think you should go into.
Oh, that's a very good point. I'm just trying to think if there's anything else we could bring up, but I was going to mention to the community that next month I'm doing a second part series, as I mentioned in the beginning of this program. So if any questions do come up about Chapter 7 or 13, we certainly can answer them next month. So if you want to email me at gwarren@warrenlawllc.com, if a question came up during today's program, we certainly could answer it next month, since we are doing the 2-part series. I do want to thank you, Jessica, for coming in today, and I think it was very informative for everyone. A lot of times people find themselves in trouble with a lot of credit debt, and they don't know what to do. So it's good to understand the differences between what a Chapter 7 or liquidation discharge chapter would be versus the Chapter 13, which is more like a reorganization type of chapter. So again, thank you for coming, and thank you for watching.
Thank you for having me.
This program was made possible through the generous support of your Medfield friends and neighbors, folks just like you. And thanks for watching.